Welcome to Ask the Lawyer, International Edition, the radio show that brings you the latest trends in immigrating to the United States. Hosted by attorney Brian Figueroa of the law firm Figueroa and Associates. This program is designed to provide valuable insights for those who wish to live, work, study, or invest in the U.S. Whether you're an international student seeking educational opportunities, an entertainer looking to break into the U.S. market, or a business owner wanting to expand your operations and tap into the vast U.S. economy, this show is for you. If you're an investor exploring options in the U.S. or someone with family or friends already living here, you won't want to miss the important information shared on Ask the Lawyer, International Edition. Each week, we dive into critical topics that help you navigate the complexities of U.S. immigration and business law. Special guests include experts in business development, elected officials supportive of immigration, business owners, and nonprofit leaders who provide real-world advice and guidance for those wanting to build a future in the U.S. The law firm of Figueroa and Associates was founded not only to serve our clients, but to contribute to the greater good. We understand the importance of helping individuals and businesses achieve their American dreams, and we are committed to providing the legal expertise and support needed to make that happen. So whether you're an entrepreneur looking to open a branch of your business in the U.S., an investor ready to explore opportunities, or someone hoping to migrate and build a new life in America, you should tune in and learn from this informative program. Ask the Lawyer. International Edition is your resource for understanding U.S. immigration trends, business opportunities, and legal strategies. Call now. For personalized legal advice, contact the experienced attorneys at Figueroa and Associates today. Our team is here to help you navigate the path to success in the U.S. Thank you for listening to Ask the Lawyer, International Edition with attorney Brian Figueroa. Visit us online at askthelawyer.us or call today to schedule your consultation.
Yes, we have an exciting show for you. Legal representation outside the United States, focus on visas to come to America, family-based petitions, green cards, and visas for entertainers. Mr. Figueroa?
Good day. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. If you are in Jamaica, if you're in Trinidad and Tobago, the U.S. market is a great market for businesses in those countries to start a branch of their business in the United States. It's called the E2 Treaty Visa. If you don't know anything about it, visit our website and we have essays on what an E2 Treaty Visa is and how you could start a branch of your business in the United States of America. We could assist you with those applications. There are already businesses from TNT, from Jamaica, that have already taken advantage of the E2 Treaty arrangement. This is an arrangement through bilateral relationships between those countries and the United States of America. Grenada is another country that is an E2 Treaty country. I am hoping that other countries in the Caribbean, whether it be St. Vincent, St. Lucia, Guyana, that they will build this relationship also to extend their businesses, their successes in the Caribbean into the U.S. It is not a work visa, it's a business visa. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer, our international edition in the Caribbean. We also urge people who want to study in the United States to get their F1 visa, their student visa. People who want to become visitors to the United States of America. Don't just go to the consulate, apply for your visitor's visa, and have it rejected. We will help you in the process so that you prepare those forms properly. And obviously, preparation is always important. So whether it be a student visa, a visitor's visa, talk to us. When you are in the U.S., obviously, if you want to extend your vacation without violating your visitor's visa, we could also work with you if an extension is necessary. The U.S. market, the U.S. in terms of tourism, whether it be Disney World in Florida, whether people want to come to the great New York City, where our law firm is located in Brooklyn, New York. People make these trips all the time, and obviously it's part of, people come here to shop, people come here to look at schools in terms of their children or themselves, and then later on, they may want to get that student visa, as we spoke about. Even business owners could come and scope out the market here as to whether or not their business could be successful. One of the larger companies here that already have a presence is Barron's Pepper Sauce. They have like factories, I believe, throughout at least 3 or 4 Caribbean countries. Their products are at the various supermarkets and Chinese corner stores that sell their products along with other products. So those of you who are listening and you want to get your foot in the door, you are a manufacturer. How do you get your product into the U.S. market? These are issues that we address on Ask the Lawyer each and every week. Again, my name is Brian Figueroa of the law firm Figueroa & Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. To schedule a consultation, go to our website, the law firm of Figueroa & Associates, at www.askthelawyer.us. Again, www.askthelawyer.us. Another visa that you might be interested in as a business person is what we call the EB-5 visa, i.e. that EB-5 leads to a green card. If you invest in the U.S. in a business, either a direct investor or through a regional center, the investor's spouse, and all the investors' children that are below 21 years old will qualify to get a green card. That investment requires that 10 Americans get jobs because of your investment. As I said, it could be a direct investment where you actually start a business or partner with another business in the U.S., or you invest in what we call a regional center, which normally invests your money in real estate development. Obviously, you have to be careful about your investment. You do not want to lose that $500,000 or $1 million that you invested in some bad deal, so to speak. So we will help you not only with the application process, but making a decision as to what is the best fit for you. Again, my name is Brian Figueroa of the law firm Figueroa & Associates. This is Ask the Lawyer. You got questions, we got answers. The EB-5 investment is normally investment.
Are you planning a trip to the United States but unsure how to navigate the visa process? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help.
And England and the US
Our experienced immigration attorneys will guide you step by step through the visitor's visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand in the way of your dream vacation. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless clients like you successfully secure their U.S. visas. Let us take the stress out of the process so you can focus on planning your perfect trip. Are you looking to study in the United States but confused about how to apply for a student visa? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in guiding students through the visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand between you and your academic dreams in the U.S. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless students secure their student visas and begin their educational journey in the United States. Let us help you make your study abroad dream a reality. Figaro and Associates, your trusted partner in student visa success. Are you a professional living overseas and dreaming of working in the United States? The H-1B visa is your gateway to achieving that goal, but the process can be complicated. That's where the law firm of Figaro and Associates comes in. Located in Brooklyn, New York, we specialize in immigration law and can guide you every step of the way. From securing employer sponsorship to navigating consular interviews, let us help you turn your dream into reality. Visit us at www.askthelawyer.us or call 855-768-8845 to schedule a consultation today. At Figaro and Associates, we're here to make the immigration process smoother, faster, and easier for you. Don't wait. Your future in the U.S. starts now. Starting a business in New York City, choosing the right business structure is critical to your success. The law firm of Figaro and Associates, located in Brooklyn, New York, can guide you through the process. From vaults and corporations to partnerships and sole proprietorships, we help you navigate the legal complexities to protect your interests. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845. Let Figaro and Associates help you build a solid foundation for your business.
Are you a lawyer with a degree from the Caribbean who dreams of practicing law in New York? The path to becoming licensed in the U.S. can be challenging, but Figaro and Associates is here to help. Located in Brooklyn, New York, our team specializes in guiding foreign-trained lawyers through the bar admission process. From prudential evaluation and additional legal education to bar exam preparation and fulfilling pro bono requirements, we're with you every step of the way. Let us help you turn your ambition into reality. Visit us at www.askthelawyer.us or call 855-768-8845 to schedule a consultation. Don't let the complexities of the U.S. legal system hold you back. Contact Figaro and Associates today.
Hi, my name is Brian Anthony Figaro, and you are listening to Ask the Lawyer with my father, Brian Figaro.
The law firm of Figaro and Associates International Legal Representation Division. In today's interconnected world, businesses and individuals from outside the United States often find themselves in need of American legal expertise to navigate complex legal matters effectively. New York, as a global economic center, is one of the most sought-after jurisdictions for international clients needing skilled legal representation. From corporate compliance to cross-border transactions and international dispute resolution, foreign individuals and companies frequently engage with New York-based lawyers to gain a competitive edge or ensure regulatory compliance. This analysis explores the types of legal representation that foreign clients seek, focusing on various aspects of business law, individual legal needs, litigation, and the key characteristics that international clients should consider when hiring a New York attorney. 1. Corporate and business law needs. A. Mergers and acquisitions. For foreign corporations looking to establish a presence or expand in the United States, mergers and acquisitions, M&A, represent a significant point of entry. M&A transactions in the U.S. are governed by intricate regulatory frameworks enforced by agencies such as the Securities and Exchange Commission, SEC, the Federal Trade Commission, FTC, and the Committee on Foreign Investment in the United States, CFIUS. Non-U.S. companies must navigate these laws carefully, as failure to comply can lead to penalties, delays, and even denial of transactions. New York law firms specializing in M&A bring extensive knowledge of these regulations and can conduct due diligence, secure regulatory approvals, and structure deals that comply with U.S. laws. B. Contract law and intellectual property protection. Contracts are fundamental to any business operation, and the enforceability of these contracts is particularly crucial when operating in foreign jurisdictions. In New York, legal professionals have in-depth knowledge of American contract law and can draft agreements that are enforceable in U.S. courts. For foreign tech, media, or financial companies entering the U.S., intellectual property, IP protection is also a priority. New York lawyers experienced in IP law help clients protect patents, copyrights, trademarks, and trade secrets, safeguarding their innovations against infringement in the U.S. market. C. Securities and investment law. Foreign businesses and investors are increasingly drawn to the U.S. capital markets. However, raising funds through stock offerings or private placements subjects foreign companies to U.S. securities regulations. New York attorneys specializing in securities law can guide these entities through compliance with federal and state securities laws, ensuring that their financial activities are legal and secure. Additionally, they can help foreign clients understand and manage the regulatory requirements that affect investment vehicles like hedge funds or real estate investment trusts, REITs. D. Real estate and commercial transactions. The U.S. real estate market is a popular investment area for foreign individuals and corporations. Real estate transactions in New York, however, involve complex legal considerations, including zoning laws, property taxes, and commercial lease regulations. For foreign clients, legal representation is essential to secure commercial properties, negotiate lease agreements, and address the legal implications of owning or leasing property in New York. Furthermore, New York attorneys can provide insights on taxes related to real estate transactions, ensuring that clients are aware of potential liabilities. Part 2. Individual legal representation needs. A. Immigration and visa representation. Foreign individuals looking to live or work in the United States often need help navigating the visa process, which can be complex and time-consuming. In New York, immigration attorneys help international clients understand the various visa options available, such as E. Investor, L. Intracompany transferee, and EB-5, Investor Green Card, categories. New York immigration lawyers are especially beneficial for clients seeking specialized visas, ensuring that their applications meet the stringent requirements set forth by U.S. Citizenship and Immigration Services, USCI. B. Employment law for foreign individuals working in the U.S. Employment law in the United States varies from other jurisdictions, and foreign professionals working here often encounter unique challenges. Non-compete clauses, at-will employment policies, and worker protections differ significantly from international norms, making New York-based legal counsel essential for foreign professionals to understand their rights and obligations. New York employment attorneys can assist foreign individuals with employment contracts, workplace discrimination issues, and wage and hour disputes. C. Family law for expatriates and international couples. Family law matters, such as divorce, child custody, and property division, can be highly complex for international couples living in the U.S. New York attorneys experienced in family law can help foreign nationals navigate these issues, especially when they involve international jurisdictions. For example, property owned abroad may be subject to different rules in the event of a divorce, and NY-based attorneys ensure that these unique circumstances are factored into settlement negotiations. D. Tax law for non-residents. Taxation of foreign nationals with U.S. income or assets is an intricate area of law. Non-residents are often unfamiliar with the U.S. tax code, which can lead to misunderstandings, penalties, or overpayment. Attorneys specializing in tax law provide non-resident individuals with advice on filing requirements, tax treaties, and estate tax implications, offering clients clarity and protection from potential liabilities. Furthermore, NY attorneys help clients plan their finances, ensuring that assets in the U.S. are managed tax efficiently. Part 3. Litigation and arbitration for international clients. International arbitration. For businesses operating across borders, arbitration is often a preferred dispute resolution method due to its efficiency and confidentiality. New York is a popular venue for international arbitration, and NY lawyers have extensive experience representing clients under arbitration frameworks such as UNCTAD and ICC. New York attorneys skilled in arbitration can assist foreign clients in structuring favorable arbitration agreements, preparing for proceedings, and securing enforcement of arbitral awards. These civil and commercial litigation. Litigation involving foreign entities often spans multiple jurisdictions and presents unique challenges. When foreign businesses or individuals face lawsuits in the U.S., NY-based litigators provide invaluable experience in both federal and state courts. These attorneys can represent foreign clients in commercial disputes, breach of contract cases, and other civil matters, guiding them through each stage of the litigation process while protecting their interests. See asset protection and enforcement of foreign judgments. Securing and enforcing judgments across international borders is complex, especially when foreign assets or court rulings are involved. New York attorneys can assist clients in protecting assets located in the U.S. and provide representation in proceedings to enforce foreign judgments. For example, they help clients secure recognition of foreign divorce decrees, inheritance rights, and debt obligations, ensuring that judgments are respected and implemented. Part 4. Key attributes to look for in NY legal representation. International clients should seek attorneys with strong cross-cultural communication skills, an understanding of foreign legal systems, and proficiency in languages pertinent to their jurisdiction. New York-based law firms that are well-versed in multi-jurisdictional cases are best suited to represent foreign clients as they navigate the complexities of U.S. legal requirements. Conclusion. In summary, New York offers a unique legal environment for foreign businesses and individuals seeking experienced representation. From M&A and intellectual property matters to family and tax law, the guidance of NY-based attorneys ensures that foreign clients' interests are represented and safeguarded. For those looking to establish, grow, or protect their assets in the U.S., firms like Figaro and Associates offer comprehensive services tailored to meet international legal needs. Schedule a consultation at www.askthelawyer.us.
Are you a professional living overseas and dreaming of working in the United States? The H-1B visa is your gateway to achieving that goal, but the process can be complicated. That's where the law firm of Figaro and Associates comes in. Located in Brooklyn, New York, we specialize in immigration law and can guide you every step of the way. From securing employer sponsorship to navigating consular interviews, let us help you turn your dream into reality. Visit us at www.askthelawyer.us or call 855-768-8845 to schedule a consultation today. At Figaro and Associates, we're here to make the immigration process smoother, faster, and easier for you. Don't wait. Your future in the U.S. starts now. Starting a business in New York City. Choosing the right business structure is critical to your success. The law firm of Figaro and Associates, located in Brooklyn, New York, can guide you through the process. From multis and corporations to partnerships and sole proprietorships, we help you navigate the legal complexities to protect your interests. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845. Let Figaro and Associates help you build a solid foundation for your business. Are you looking to study in the United States but confused about how to apply for a student visa? The law firm of Figaro and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in guiding students through the visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand between you and your academic dreams in the U.S. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless students secure their student visas and begin their educational journey in the United States. Let us help you make your study abroad dream a reality. Figaro and Associates, your trusted partner in student visa success.
Are you a lawyer with a degree from the Caribbean who dreams of practicing law in New York? The path to becoming licensed in the U.S. can be challenging, but Figaro and Associates is here to help. Located in Brooklyn, New York, our team specializes in guiding foreign-trained lawyers through the bar admission process. From prudential evaluation and additional legal education to bar exam preparation and fulfilling pro bono requirements, we're with you every step of the way. Let us help you turn your ambition into reality. Visit us at www.askthelawyer.us or call 855-768-8845 to schedule a consultation. Don't let the complexities of the U.S. legal system hold you back. Contact Figaro and Associates today.
Are you planning a trip to the United States but unsure how to navigate the visa process? The law firm of Figaro and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys will guide you step by step through the visitor's visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand in the way of your dream vacation. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless clients like you successfully secure their U.S. visas. Let us take the stress out of the process so you can focus on planning your perfect trip.
Hi, my name is Brian Anthony Figaro, and you are listening to Ask the Lawyer with my father, Brian Figaro.
For many artists, bands, and musicians worldwide, performing in the United States represents a significant opportunity to expand their careers and connect with a global audience. The U.S. entertainment industry is one of the most vibrant and diverse markets, offering international performers the chance to reach new fans, collaborate with American talent, and experience the rich cultural landscape of the country. However, to legally perform in the U.S., artists, musicians, and entertainers must obtain the proper visa, usually under the P visa category. In this comprehensive guide, we will analyze the process for an artist, band, or musician living overseas to successfully apply for an entertainer visa, specifically the P1, P2, and P3 visas. We'll cover the eligibility requirements, application procedures, the role of the U.S. consulate in the process, and practical advice for navigating the complexities of U.S. immigration law for performers. Understanding U.S. entertainment visas, P1, P2, and P3. The P visa category is designated for internationally recognized performers, artists, and entertainers who want to come to the U.S. to participate in a specific event, tour, or performance. Unlike the O1 visa, which is for individuals with extraordinary abilities, the P visas are tailored for those who are part of a group or collaborative effort and may not necessarily need to meet the same stringent requirements. Here's a breakdown of the three main types of P visas. P1 visa, internationally recognized performers. The P1 visa is for artists, bands, and entertainers who are part of a group that is internationally recognized. It allows foreign nationals to come to the U.S. to perform in an internationally recognized entertainment group, participate in an event, or compete in a cultural or sporting event. Eligibility. To qualify for a P1 visa, the group or individual must have an internationally recognized reputation in their field. This means that the group or act should have achieved recognition beyond their home country and be well known in multiple countries. Duration. The P1 visa is granted for the duration of the performance or event, typically not exceeding 1 year. Extensions are available in 1-year increments as long as the performer remains engaged in the same event or tour. P2 visa, reciprocal exchange program. The P2 visa is for artists or entertainers who are participating in a reciprocal exchange program between an organization in the U.S. and one in another country. This visa is designed to facilitate cultural exchange through performances, workshops, or collaborative artistic endeavors. Eligibility. Applicants must be part of a reciprocal exchange program recognized by the U.S. government. The exchange program must involve artists of similar talent and background in both countries, ensuring equal opportunities for both American and foreign participants. Duration. The visa is granted for the length of the exchange program or event, not exceeding 1 year, but extensions are possible under certain conditions. P3 visa. Culturally unique artists. The P3 visa is for performers or entertainers who are coming to the U.S. to participate in a culturally unique program. This visa allows artists to present, teach, or coach performances that highlight cultural traditions, ethnic expressions, or folklore unique to their home country. Eligibility. The applicant must prove that their performance is culturally unique and that they will participate in an event, program, or workshop that highlights or promotes their cultural heritage. Duration. The P3 visa is granted for up to 1 year, with the option to apply for extensions. Each of these visa categories has specific requirements and procedures, but they all share the common goal of allowing foreign artists, entertainers, and performers to legally work and perform in the U.S. Step-by-step process for applying for an entertainer visa. Step 1. Secure a U.S.-based sponsor or employer. The first step in obtaining a P visa is securing a U.S.-based sponsor or employer. Unlike tourist visas, which are self-petitioned, a P visa requires a petition from a U.S. organization, agent, or employer. This could be a concert promoter, music festival organizer, cultural institution, or a venue hosting the performance. Who can be a sponsor? The sponsor must be a U.S. entity or individual who has the authority to petition on behalf of the artist or group. The sponsor is responsible for submitting the visa petition and must show evidence that they are hiring the foreign performer for a legitimate event, tour, or project in the U.S. Step 2. File Form I-129, Petition for an Immigrant Worker. Once a sponsor or employer is identified, they must file Form I-129, Petition for an Immigrant Worker, with the U.S. Citizenship and Immigration Services, USCIS. The I-129 form is the primary application that sets the process in motion and must be completed by the U.S. petitioner. Supporting documents. Along with Form I-129, the petitioner must submit supporting documentation that includes a detailed explanation of the event or performance schedule, contracts or letters of intent outlining the terms of the engagement, proof of the artist's or group's eligibility, e.g. international recognition for P1, evidence of a reciprocal exchange for P2, or proof of cultural uniqueness for P3, documentation of previous international performances or tours for P1. Filing fee. As of 2024, the filing fee for Form I-129 is $460, though it's essential to check the latest USCIS fees. Step 3. Wait for USCIS approval. Once Form I-129 is submitted, USCIS will review the petition to ensure it meets all the requirements for the specific P visa category. Processing times for USCIS can range from several weeks to several months. However, for those needing faster processing, premium processing is available for an additional fee, which expedites the decision within 15 calendar days. Approval notice. If USCIS approves the petition, they will issue a notice of approval, Form I-797, which is necessary for the next step, applying for a visa at a U.S. consulate. Step 4. Apply for a visa at the U.S. consulate. Consular processing. Once USCIS approves the petition, the artist, band, or musician must apply for their visa at the U.S. consulate in their home country. This step involves several important tasks. Complete Form DS-160. All visa applicants must fill out Form DS-160, the online non-immigrant visa application. This form collects personal and background information about the applicant, including details about previous travel, employment history, and intended activities in the U.S. Schedule a visa interview. The applicant must schedule an interview at the U.S. consulate or embassy in their home country. The wait time for interview appointments varies depending on the location, so it's important to book the appointment as early as possible. Documents to bring to the interview. Passport. Valid for at least 6 months beyond the intended stay in the U.S. Visa application fee payment receipt. As of 2024, the fee is $190 for P-Visas. Form I-797, Notice of Approval from USCIS. Confirmation page of Form DS-160. A passport-sized photo that meets U.S. visa requirements. Any additional documentation that supports the purpose of the trip, aid contracts, event details, or a letter from the sponsor. Visa interview. During the visa interview, a consular officer will ask questions to determine the purpose of the visit, the duration of the stay, and the artist's ties to their home country. The officer will also verify the details provided in the visa application and the I-129 petition. If the interview is successful, the visa will be approved. Step 5. Enter the U.S. and begin performing. Once the visa is approved, the applicant will receive their visa stamp in their passport. The visa allows them to enter the U.S. for the specified duration of their performance, tour, or event. Upon arriving at a U.S. port of entry, they will be inspected by a Customs and Border Protection (CBP) officer who will issue an I-94 arrival departure record that specifies how long the artist can remain in the U.S. Special considerations for artists, bands, and musicians. Multiple members of a group. For bands and performing groups, the P-1 visa can cover all members of the group if they meet the criteria for international recognition. However, each member must be part of the group for at least 1 year before the application, except in cases of illness or other emergencies that necessitate temporary replacements. Essential support personnel. In addition to the main performers, essential support personnel, such as sound engineers, makeup artists, or production crew, can also apply for P-visas under the P-1S, P-2S, or P-3S categories. These visas are for individuals who are integral to the success of the performance and who have critical skills that cannot be easily replaced by a U.S. worker. Traveling on multiple performances or tours. Artists, musicians, or bands planning multiple performances or tours in the U.S. can apply for P-visas that cover the entire duration of their tour schedule. If the performance schedule changes, the sponsor or agent must notify USCIS and, if necessary, file an amendment to the original I-129 petition. Dual intent and future immigration options. While the P-visa is an immigrant visa, it allows for dual intent, meaning the artist can apply for permanent residency, green card, later if they meet eligibility requirements. This is particularly important for artists who may wish to pursue a more permanent career in the U.S. The U.S. offers a vibrant and diverse landscape for artists, bands, and musicians from all over the world to showcase their talents and contribute to the cultural richness of the country. However, to legally perform in the U.S., foreign artists must navigate the complexities of U.S. immigration law, specifically by applying for the appropriate P-visa category. The process of applying for a P-visa involves securing a U.S.-based sponsor, filing Form I-129 with USCIS, and attending an interview at the U.S. consulate in the applicant's home country. While the process can be complex, careful preparation and attention to the specific requirements of each visa category can help ensure a successful application. For artists looking to pursue multiple performances, tours, or cultural exchanges, the P-visa offers a flexible and reliable pathway to performing in the U.S. The law firm of Figueroa and Associates, which has over 25 years practicing immigration law, can help you navigate the process and avoid common pitfalls. To schedule an appointment, visit www.askthelawyer.us or call 855-768-8845. The lawyer you hire does make a difference. Are you an artist, band, or musician looking to perform in the United States but need help navigating the complex visa process? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to assist. Our experienced immigration attorneys specialize in entertainer visas, including P-1, P-2, and P-3 visas. We'll guide you through every step, from securing a U.S. sponsor to filing the necessary petitions and preparing for your consular interview. With our legal expertise, we'll ensure that your visa application process is smooth and stress-free so you can focus on what you do best, performing. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Figueroa and Associates, your trusted partner in U.S. immigration law for entertainers. Are you looking to study in the United States but confused about how to apply for a student visa? The law firm of Figaro and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in guiding students through the visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand between you and your academic dreams in the U.S. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless students secure their student visas and begin their educational journey in the United States. Let us help you make your study abroad dream a reality. Figaro and Associates, your trusted partner in student visa success. Are you planning a trip to the United States but unsure how to navigate the visa process? The law firm of Figaro and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys will guide you step by step through the visitor's visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand in the way of your dream vacation. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless clients like you successfully secure their U.S. visas. Let us take the stress out of the process so you can focus on planning your perfect trip.
Hi, my name is Brian Anthony Figaro, and you are listening to Ask the Lawyer with my father, Brian Figaro.
One of the most common pathways to obtaining permanent residency, commonly known as a green card in the United States, is through family-based immigration. U.S. citizens and lawful permanent residents, green card holders, can petition for certain family members living overseas to join them in the U.S. and apply for permanent residency. This process is known as family-based immigration, and it requires several steps that must be carefully followed to ensure success. In this article, we will break down the process for someone living overseas to have a U.S. citizen or green card holder family member petition for their green card. We will also explore how this process might impact any existing U.S. visitor visas, what to expect in terms of timelines, and potential challenges that may arise. Overview of family-based immigration. Family-based immigration allows U.S. citizens and lawful permanent residents, LPRs, to sponsor certain relatives to immigrate to the United States. The process involves filing a petition, going through consular processing for family members overseas, and ultimately obtaining a green card. Categories of family members eligible for sponsorship. The eligibility to sponsor a family member for a green card depends on the petitioner's status, whether they are a U.S. citizen or green card holder, and the relationship to the relative. For U.S. citizens, they can sponsor immediate relatives, which include spouses, parents, if the petitioner is over 21, and unmarried children under 21 years old. These categories are not subject to visa quotas, which means there is no waiting period once the petition is approved. Other family members, including unmarried sons and daughters over 21. Married children of any age, siblings, if the petitioner is over 21. For green card holders, lawful permanent residents, they can sponsor spouses. Unmarried children regardless of age. Green card holders cannot sponsor married children or siblings. Preference categories and visa availability. Family-based immigration for relatives outside the immediate relatives category is subject to visa availability under the preference category system. Immediate relatives of U.S. citizens are not subject to numerical limits, but other family categories like siblings of U.S. citizens or spouses of green card holders are subject to annual limits, which can create long waiting times depending on the relationship and the petitioner's country of origin. First preference, F1, unmarried adult children over 21 of U.S. citizens. Second preference, F2A and F2B, spouses and children of green card holders, F2A, and unmarried adult children over 21 of green card holders, F2B. Third preference, F3, married children of U.S. citizens. Fourth preference, F4, siblings of U.S. citizens. Once the petition is approved and the visa becomes available for the relative, the process moves forward to consular processing or adjustment of status if they are already in the U.S. Step-by-step process for family-based green card petition for overseas relatives. Step 1. Filing Form I-130, Petition for Alien Relative. The process begins when the U.S. citizen or green card holder files a Form I-130, petition for alien relative with U.S. Citizenship and Immigration Services, USCIS. This form establishes the family relationship between the petitioner, U.S. citizen or green card holder, and the beneficiary, the relative living overseas. Supporting documents. The petitioner will need to submit supporting documents proving their relationship with the beneficiary. This may include birth certificates, marriage certificates, or proof of adoption, depending on the relationship. Filing fee. As of 2024, the filing fee for Form I-130 is $535, but it's advisable to check the USCIS website for current fees. Once USCIS receives the I-130 petition, they will review it and either approve or deny the application. Processing times can vary, but it generally takes several months for USCIS to adjudicate the I-130 petition. Step 2. Wait for approval and visa availability. If the I-130 petition is approved, the next step depends on the family member's category. Immediate relatives, spouses, parents, unmarried children under 21 of U.S. citizens. These applicants can proceed directly to the next steps, as visas are immediately available. Preference categories. A. Adult children, siblings. For relatives who fall under preference categories, the approved petition enters the visa queue. Because of annual visa caps, applicants may have to wait for their priority date, the date the I-130 petition was filed, to become current based on the Visa Bulletin, which is updated monthly by the U.S. Department of State. Step 3. Consular processing for overseas relatives. Once the visa is available, overseas applicants go through consular processing. This involves the following steps. National Visa Center, NVC processing. After USCIS approves the petition and the visa becomes available, the case is transferred to the National Visa Center, NVC, which collects fees and documentation to prepare for the visa interview. Complete Form DS-260. The beneficiary, overseas family member, must complete Form DS-260, which is the online immigrant visa application. This form asks for detailed personal information, including background, employment history, and travel history. Submit supporting documents. The NVC will also require submission of supporting documents such as police clearance certificates, medical exams, financial support affidavits, and civil documents like birth certificates and marriage certificates. Pay visa fees. Fees for the immigrant visa application, affidavit of support processing, and medical exam must be paid during this stage. As of 2024, the total cost of consular processing can range from $300 to $400, depending on various factors. Step 4. Attend the visa interview at the U.S. consulate. Once all documents are submitted and processed, the applicant will be scheduled for a visa interview at the U.S. Embassy or consulate in their home country. During this interview, a consular officer will ask questions to verify the relationship, ensure that the applicant is eligible for immigration, and assess the legitimacy of the application. Bring required documents. The applicant must bring all required documents to the interview, including their passport, photos, medical exam results, and financial support documentation. Outcome. If approved, the beneficiary will receive an immigrant visa in their passport, which allows them to travel to the U.S. as a lawful permanent resident. Step 5. Enter the U.S. and receive the green card. Upon entering the U.S. with the immigrant visa, the beneficiary will be processed by Customs and Border Protection, CBP, at the port of entry. They will receive a stamp in their passport, which serves as proof of lawful permanent resident status, green card, until the official green card arrives by mail. Impact of family-based green card petition on a visitor visa. Many individuals who have a visitor visa B1/B2 to the U.S. may wonder how filing for a green card through a family member might affect their current visa status. Here are a few key points to consider. Dual intent. A visitor visa is intended for short-term stays for purposes like tourism, medical treatment, or business. The visa does not allow the holder to remain in the U.S. permanently. Filing a family-based green card petition could raise concerns about immigrant intent, as applying for a green card indicates a desire to stay in the U.S. permanently. This can potentially lead to challenges if the individual tries to enter the U.S. on a visitor visa while their green card application is pending. Visa denial or revocation. If a visitor visa holder applies for a green card, their visitor visa may be scrutinized more closely. In some cases, visa officers at U.S. embassies or consulates could deny or revoke the visitor visa, particularly if they believe the individual intends to overstay their visa while waiting for their green card. Honesty at the border. If someone holding a visitor visa tries to enter the U.S. while they have a green card petition pending, they should be prepared to explain their intentions honestly to U.S. border officials. Misrepresenting their intentions can lead to a visa being canceled or even a ban from entering the U.S. In summary, filing for a green card through a family-based petition can affect a person's visitor visa. It's essential to consult an immigration attorney before traveling on a visitor visa during the green card application process. The family-based green card process for relatives living overseas involves multiple steps, from filing the initial I-130 petition to attending a consular interview and entering the U.S. as a lawful permanent resident. For U.S. citizens and green card holders, this process is a way to reunite with family members in the United States, but it requires careful preparation and attention to legal details. Furthermore, it's important to understand the potential impact of filing a green card petition on an existing visitor visa. Navigating these complexities can be challenging, so working with an experienced immigration attorney can be essential in ensuring a smooth process. The law firm of Figueroa and Associates, which has over 25 years practicing immigration law, can help you navigate the process and avoid common pitfalls. Schedule an appointment at www.askthelawyer.us. Do you have a family member overseas that you want to bring to the United States? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you are a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay, but the law firm of Figueroa and Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Get the right legal help when it matters most.
Starting a business in New York City, choosing the right business structure is critical to your success. The law firm of Figueroa and Associates, located in Brooklyn, New York, can guide you through the process. From Mulfs and corporations to partnerships and sole proprietorships, we help you navigate the legal complexities to protect your interests. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845. Let Figueroa and Associates help you build a solid foundation for your business. Are you an artist, band, or musician looking to perform in the United States but need help navigating the complex visa process? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to assist. Our experienced immigration attorneys specialize in entertainer visas, including P1, P2, and P3 visas. We'll guide you through every step, from securing a U.S. sponsor to filing the necessary petitions and preparing for your consular interview. With our legal expertise, we'll ensure that your visa application process is smooth and stress-free so you can focus on what you do best, performing. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Figueroa and Associates, your trusted partner in U.S. immigration law for entertainers.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figueroa of the law firm Figueroa and Associates in New York. We hope you enjoyed the show, which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.